Good morning, everybody. My name is Rosa Orenstein, and welcome to our monthly meeting of the North Texas Renewable Energy Group. As you know, we have presentations every month, and this month is a longer membership meeting than usual, and then a short update on the solar laws that were passed by the legislature this year. But before we do anything, after welcoming you, as I'm sure everybody here knows, this is the 20th anniversary of the 9/11 attacks on this country, and we lost a lot of people. And I'd like to take a moment for everybody to have a moment of silence to remember all the victims of the 9/11 attacks. So let's just take a moment to reflect on everything that we lost as a country on that day. Thank you very much. Let's get started. Lisa, unfortunately, cannot join us today, so I'm going to fill in for her. We have everything we do here is based on your support and your participation, whether it's monetary or otherwise. Our membership fees are very reasonable. They're $20 a year. And based on just on the content of the presentations that are made every month, any one of those would easily support a $20 contribution. We ask you to go to our NTREG website, and there are buttons there for you to donate at any level, and any contribution and donation is welcome. We do have costs for the program, such as the Zoom accounts, so that we can bring these presentations to you. And while we still cannot meet in person because of the resurgence of the COVID-19, please know we are diligently working to bring that to you as quickly as possible. Lisa also sends out reminder notices when your membership is about to lapse. Please don't let it sit idle, and please come and join us and come take the full ride, including a donation at whatever level you may be able to contribute. Mark, do you want to bring the membership up to date on the special events and projects we have going, especially
Yes.
the solar tour?
Yeah, thank you, Rosa. So the main thing I want to talk about at this point in the meeting is just NTREG making our Solar 101 Energy Efficiency 101 presentation to outside groups. I don't think it's any secret that this group has an inordinately large amount of knowledge and expertise regarding solar energy, renewable energy in general, and energy efficiency. And we really need to get that information out to other groups and make sure that other people understand the benefits of renewable energy and energy efficiency. And our goal is to make at least one outside presentation per month. We've fallen short of that goal, quite frankly, but that's where I would like to request that all members, if you know of some group that would like for us to give them a presentation or need a presentation for their monthly meeting or quarterly meeting or what have you, that's the kind of thing we can do. We will be happy to come to wherever they are and make our Solar 101 presentation. And as far as the 2021 DFW solar tour. I will give that update when I give my presentation a little bit later on in this meeting.
Thank you, Mark. Mark, is it possible for some of our members, if they want to be speakers, to contact you and get prepared so that they too can make presentations to outside groups?
Yes, absolutely.
So anybody that's a member of NTREG who wants to be a speaker to make presentations as we are requested and we seek them out, please contact Mark, because you too can become a speaker and represent not only yourself, but NTREG out there in bringing renewable energy and sustainability presentations to the community at large. Michael, I know you have been working diligently with the community project that we undertook as a group in January of this year. Do you want to bring the membership up to date on the CECAP and what you've been doing?
Yes, thank you, Rosa. So we had the good fortune of working with the city of Dallas in regards to meeting 2 deliverables for their fiscal 2021 CECAP activities. And we previously submitted the first one, which was referred to as the B15 Resilience Hubs questionnaire, basically. And it's been submitted and received by the city staff. And we just recently, this last week, submitted the second one, which dealt with option or action E6 of the CECAP, which dealt with renewable energy hubs. And so we prepared a technical specifications overview for the city to be able to use in developing their requests for projects in the city to develop and build these renewable energy hubs. So once those are finalized and the new budget for 21-22 is available, we'll make those reports available on our website. But I don't want to steal any thunder, but I do want to make an announcement that our speaker next month is going to be Susan Alvarez, who is the Deputy Director for the Office of Environmental Quality and Sustainability for the City of Dallas, who manages the CECAP program, is going to talk about the status of the program, and she'll be making comments in regards to our relationship and the reports that we did submit. So stay tuned. Look forward to being able to have that presentation next month. And that's all I really have. Thanks.
Thank you, Michael. And just as a reminder, if you're not speaking, please keep your microphone muted so that we can get as good a sound quality as possible and everybody can hear what's being said. I'm gonna deviate just a tiny little bit from the agenda because I wanna reemphasize the internship program that NTREG has undertaken in conjunction with the Texas Solar Energy Society. Some of you may have seen the blast that went out in early September. We have launched an internship program for attempting to help to diversify the renewable energy industry. And to that end, we have been tasked by Texas Solar Energy Society to find 6 interns with 6 renewable energy companies. Now, these positions can be for marketing, they can be for web design, they can obviously be for solar installation, technical, architectural, business. And so we have started it. We are working with 4 different colleges in the North Texas area to recruit interns from their colleges. We are seeking additional colleges to work with because there's so many here in the North Texas area. And we have posted right now 2 job openings from 2 entities that have requested interns. The information, frankly, is located on the NTREG website on the first page. All the forms and applications are there. So if you know a college student that might be interested, please send the information to them or the link to them. By the same token, anybody here on this meeting that has a company and is interested in having an intern, this is the perfect opportunity. There is some availability to help support the payment to the intern, and that's done on a case-by-case basis. But please contact me or anybody on the board with your request, and we can start the process going. So I just want to take off, sorry for that, getting off of the agenda, but I thought this is a very exciting and important step that NTREG is taking, and we need your support, not only to help us find interns, but if you yourself as a company want to have an intern, this is an opportunity for you to do so. And then lastly, we need mentors for those 6 interns. As Mark has said, we have a tremendous amount of knowledge and skill in the renewable energy area in this group, and it won't be a large commitment of time, and you'll be assigned to an intern, but that way they will have somebody outside their employee group that they can visit with and be able to bounce off ideas, or if they have any challenges or problems, they have somebody that they can confide in and be able to help. So I would ask you to please volunteer and help us move this internship program forward. Usually we have in our meetings, this is a time when members may make announcements to the group. Do any members who are here in the meeting have any announcements on any activities related to renewable energy or sustainability that they would like to make at this point? Just go ahead and unmute yourself and make that presentation or that announcement. I don't hear anybody. How about any guests that are here that wish to make an announcement? Anybody? No? Okay. Climate Reality Project, that's a group that we have been working with for quite a while, and we try to have a joint meeting at least once a year with them. We're trying to plan that for January or February of next year. And then their meetings are the 3rd Saturday of the month from 1 to 3 p.m. Is there anybody from Climate Reality Group in the meeting today that wish to make any announcement? Okay, everybody's busy today. If you want to do so, then since we don't have any of those, I guess, Michael, let's go ahead and start moving to the presentations for today. Michael, are you there?
Hello, everyone. You hear me okay now?
Yes, sir.
Okay. So we have 2 presenters today, and the first one is going to be by Mark Whitty, who's the chair of our 2021 DFW Tour Committee. And our second presenter will be Rosa Orenstein, and she'll be presenting on Texas solar laws passed in 2021. So Mark, if you're ready, please make your presentation.
Thank you, Michael. I appreciate that. Hello, everyone, and hope everyone has a great day today. A little update on the 2021 solar tour. The tour will be virtual again this year because of lingering COVID concerns. Up to this point, it's primarily been 3 people working on the solar tour: James Ornstein, Mellon West, and me, probably in that order. Good news is we have enough money from our sponsors to pay for the tour this year. Not to say we won't accept additional sponsors or additional money, we will. That would be great if we get some additional money for the tour, but it isn't necessary. It's not required for the solar tour to go forward this year. We actually need 2 things, and I want to request that the membership at large help out if they possibly can on the 2 things that we need. One is we need additional partners, not sponsors, partners. What is a partner? It's never really been officially defined, but a partner is basically an organization that would be willing to advertise the tour publicly or to their membership. And that could be as little as just sending out an email with an announcement to their membership about the tour. Because ultimately the tour needs to get as much publicity as possible so that we get as many people as possible attending the tour. And, you know, there's no amount of publicity that's too much for this tour or for any of our tours. So if anyone knows an organization that would like to be a partner of NTREG for our solar tour, please let us know, especially if you know them personally. Let us know. And if need be, you know, you can call them, we'll talk to us first, make sure that we aren't already talking to someone in that organization. But, you know, definitely we're looking for additional partners. The other benefit of having all these partners associated with the tour is it makes it look more compelling. The partners give us gravitas to show that, you know, we've got all these well-known organizations that are partnering with us for the tour. We get benefited out of that. Just when people log on and see the different entities that are partnering with us. So again, we're going to request to the membership at large that if you know someone, if you're part of an organization that would be willing to help us publicize the tour, let's talk, because again, we want to get the message out as far and as wide as we can. Second thing is, and again, we're going to request this for the membership at large in general, is we need to find short videos. When I say short, I'm talking 5 minutes or less, of unique solar installations. And what I mean by unique is we have videos of people with panels on their homes, and the panels might be leased, they might be purchased, they might have been put up as a do-it-yourself project, or they might have been put on there by a contractor. We kind of have those covered. So what we're looking for in, say, a residential video is someone that has a solar roof like Tesla. I'm not trying to plug Tesla here, but I'm using that as an example. They have Tesla solar tiles on the roof so that the entire roof is basically a large solar panel. So if we have something like that, if we have a video of someone that has a power wall in their garage or somewhere in their house that is collecting the electricity from the roof and storing it so that they have their backup there in case they need it, That would be good. Then as far as commercial type of videos, I know we have some from IKEA, we have some from different places, but again, if there's something that is unique, it's some kind of video we don't have, whatever it may be, and it might be just some business that's put up solar parking structures, and then they have outlets for cars right underneath. So literally they can be charging the cars from the solar energy that's hitting the solar structure, parking structure. That would be unique. And so what we're trying to do is get a wide range of solar installations to give people an idea that it's almost unlimited what you can do with it. And so that's why we need, additional videos. And again, we're making a request for everyone in the organization. If you know of some entity that has a good video that we might use and they're willing to let us use it, but let's talk to them. Let's look at the video. And if it's something unique, then let's use it. And so that's where we would like to get help from everyone in the organization. We are updating the website, and I don't know if all of you know, but the website for 2020 got a virus, basically shut it down. So we had to rebuild it with a different software for 2021. And hopefully it's hack-proof or largely hack-proof, so we don't have to worry about viruses. But we're trying to finish up that website sooner rather than later. And so we will, we're shooting to have that finished, in the next week or 10 days. And the tour is 3 weeks from today. So y'all keep looking at the website. We'll try and provide updates for the website or on the website so y'all can see where we are on a going forward basis. And open for any questions from the group. And if you
Mark, this is Rosa Orenstein. I'm wondering if the membership and the people on the meeting are wondering if there's going to be Q&A sessions like there were last year. Could you comment on that?
Yeah, there will be Q&A sessions. Obviously we have got to talk to people and make sure they're on board. We have a couple of people that have expressed willingness to do the Q&A. I think one of them will only be able to do it in the morning because of a previous obligation in the afternoon, but normally we try and have a couple of Q&A sessions for each host, one in the morning, one in the afternoon, moderated by someone from NTREG that is involved in the solar tour.
Anybody in the meeting have any questions for Mark?
So again, can everyone contact me? Let me give you my personal cell phone number and my personal email address, so that if you do know someone that has, again, that wants to be a partner with us for the solar tour and can help publicize it and get the word out, then let's do it. Or if you know of someone that has a compelling, unique type video, then by all means, pass along to me. So my cell phone number is 972-897-2098. That's my personal cell phone that's with me all the time. And my email address is just witte.m@att.net. So please send me any information, any suggestions or questions you may have, even if they're unrelated to getting additional sponsors or unique videos, go ahead and send me your questions or comments. I'm happy to get them.
Hey, Rosa, this is Dharma. Sorry for joining in a little late. You might have already covered this. In terms of the sequence of the presentations, I guess last year we kicked it off with the Solar 101, and then we transitioned into the different homeowners who were showcasing their installations, and then giving a brief overview of their setup and then answering Q&A. Are we still following that format, Mark, or how are you laying out this the structure for the proceedings in about 3 weeks' time?
Yeah, and I agree. I like the idea of kicking it off with the Solar 101 presentation, and we might even run that a couple of times during the day, one in the morning, one in the afternoon, kind of like we do with the Q&A sessions. Yeah, I think we do that, and then we just schedule the home videos and the Q&A sessions to follow up with that. And then to the extent we don't have Q&A or they're just videos, we'll just have those posted on the website.
Okay, thanks.
Any other questions by anybody in the meeting of Mark?
Yes, could I ask a quick question?
Please,
Sure.
Rob.
So I think I missed the virtual tour. Is it sort of a live virtual tour? Or is it all recorded and you go through at your own pace?
Well, we're gonna have, we will have a bunch of videos on the Solar Tour website, and they're gonna be broken out by the different types, like residential will be one group, commercial will be another. If we have people that are interested in doing a Q&A and are willing to do a Q&A, then we would probably run the video. If it's a good video, obviously we can use it even if it's from last year, but we'd run the video and then have a live Q&A session with that person, about their particular home. Obviously, we would probably have more videos than we would have time if we're going to do a Q&A session with these people, because the whole tour, is only 6.5, 7 hours. So we will have probably as many Q&A sessions as we can, but to the extent, again, that we have videos from groups that don't have Q&A sessions, then we'll just have their videos posted on the Solar Tour website. So you can click on them.
So it's basically a lot of videos to watch, and then maybe there's some live Q&A, and then all that's recorded, and somebody could at a later date go through the whole thing at any time.
Correct.
Okay, thank you.
Thank you.
Any other questions? Molly has something on the chat. What people need to do to be able to use their solar during outages, for the Solar 101 presentations for the DFW Solar Tour.
Yeah, okay. And that's just in general for the Solar 101 presentation.
Yeah, thank you, Molly.
Thank you, Mark.
Thank you.
Any other questions? Okay. Well, thank you very much, everybody. Michael, do you want to switch over now to the next presentation?
Yes, I'm going to share my screen with your presentation. Bear with me. Okay, does everyone see that?
Oh, I'm not seeing the full slide. I'm seeing part of it.
Okay. I don't know why it's doing that. It's still only showing part, correct?
Yes,
So I'm going to go
there
back
it
and show.
is.
Okay, very good. All right, everyone. Our presenter is our illustrious chair, Rosa Orenstein. And maybe a lot of you don't know that she comes to us. She's a lawyer. She's been practicing for a number of years. She did her undergraduate degree at Stanford in economics, then went on to law school and got her degree at UC Berkeley. And she's been practicing law in Texas primarily since then. She's actually certified to practice before the US Supreme Court. And she focuses on, and you can correct me if I'm wrong here, Rosa, but specialty law focused on bankruptcy, I think, if that's correct. But, you know, the interesting part, you know, she's been our chair for the last 4 years. She's done a tremendous job turning us around and getting us focused going forward. But, you know, what originally brought her and James to our organization was back in the early 2000s, they actually had the initiative to study and learn through Solar Energy International how to design and install their own solar system on their house, which they did. And actually Rosa devised a pulley system to be able to pull, to get the panels up to their roof. So she's had an interest in solar, renewables, sustainability for a long time. But because of her law practice, she does bring a special expertise. And so part of that is what we're going to do today. She's going to make a presentation on the most recent Texas legislation on impacts on solar for both us as individuals, as homeowners, and for business. So I'm going to turn it over to Rosa. Thank you very much.
Thank you, Michael. I'm going to digress for just a moment and add a little bit on what brought us to NTREG. And in light of the fact that this is the 20th anniversary of the 9/11 attacks, frankly, that was one of the things that brought us here. I was so angry that day at what had happened to us. You know, I had to let the anger subside and then think about how do you move forward, you know, with people who clearly are very unhappy with us being in their countries. And one of the big issues was we were in their countries in part for the fossil fuels, for the oil, and the gas. And so one of the things that both James and I started looking at was, how do you solve that problem? Well, that problem gets solved by using less of their resources. Because at that time, you all may recall that the US was a net importer of oil and gas, and primarily from the Middle East. So coincidentally enough, or that's why I'm here. That's why I started looking around, and so did my husband, at alternative sources of energy. And that's what brought us to NTREG. So I hadn't made that connection until you were talking right now, Michael. So thank you all very much. Let us get started. Our normal process over the last 4 years has been to bring a state legislator to tell you about the laws that were changed in that legislative session that could affect renewable energies or sustainability in the state. And as you all know, there have been a number of special sessions this year so that the person we had locked in, the legislator we had locked in to come in and talk to us in September about what had happened to renewable energy and to sustainability in the 87th legislative session, the regular session. Frankly, they ended up not being able to do it, partly for reasons that they have to go back to the legislature, but also because they had some family matters that they had to go take care of, and so they couldn't join us. So unfortunately for you, you're stuck with me. So let's move on to the next slide, Michael. Thank you. In this legislative session, as you can see here, almost 10,000 bills were filed. According to the Texas legislature reference library, 3,803 of those bills were passed, and 21 were voted. Though that doesn't quite coincide with the next slide, if you don't mind, Michael. 600 new laws actually went into effect on September 1, 2021. Some of them went into effect earlier because based on the way the Texas legislature works, if it gets more than 3/4 of the vote, both in the House and Senate, the bill can go into effect immediately. And then some of them go into effect later in the year. So that's part of why 600 new laws went into effect come September 1, 2021. Next slide, please. Of those 600 new laws, 5 House bills affecting renewable energy became law. 6 of the Senate bills affecting renewable energy became law. And it impacted 10 different Texas codes. So I will tell you that even though 5 House bills became law, the more significant ones this year from the standpoint of specifically the grid that I know everybody is very concerned about actually came from the Senate. It's usually the other way around, where more of the bills that become law emanate out of the House. So what are the kinds of codes that were affected? The Utilities Code was affected. The Natural Resources Code was changed. The Water Code was changed. The Business and Commerce Code was changed. The government, including the Local Government Code, was changed. The Health and Safety Code was affected. The Occupations Code was changed. The Property Code was changed. The Tax Code was changed. And the Transportation Code was changed. All these codes were amended in one form or another that affected renewable energy. And as you can tell from what I'm going through, it would be impossible for me to tell you in detail and discuss in detail each of the laws that were changed. There just would not be enough time, frankly, the rest of today to cover that. So I am focusing on 3 different laws that were changed. 2 of them affect residential consumers, and 1 of them specifically affects businesses. So some of the things I'm not talking about. So for example, Senate Bill 2, I'm not going to really cover that in detail. That changed the ERCOT board structure. I'm sure some of you have read how board members now have to be residents of the state of Texas. Well, it made other changes as well, but I'm not going to cover that. That was Senate Bill 2. Senate Bill 3, for example, created the Texas Energy Reliability Council, which creates the alert system that's going to be developed and going into place for when we have extreme heat events, power outages, and extreme cold events, as we all experienced in February. The reason I'm mentioning that those particular two bills, Senate bills, are because that is an opportunity for you as voting citizens of the state of Texas can contact your Senate or House representative and let them know the kinds of people that you want to see on this new Energy Reliability Council. You will have input by contacting your state and House representatives. Another bill that I'm not going to cover is Senate Bill 1281, which actually requires ERCOT to conduct a biennial assessment of the ERCOT power grid and to assess the grid's reliability in extreme weather scenarios. You might want to go look at that because that is another area where you might have input through your representatives. And in Senate Bills 2 and 3, you will also have input because it affects the PUC and everything they do has to be sent out for comment before it's adopted. So I'm not going to cover those because frankly, it would take so much time that we would not have enough time here to cover those. There's another major one, which I'm not going to cover, is House Bill 4472. And that is one of the main bills, and House Bill 4492. Those two bills are the ones that you have probably read the most about in the newspapers and in articles, because those are the ones that are creating the financing mechanism for utilities and other providers, generators of energy in Texas to basically borrow money, which the state of Texas is going to be issuing bonds. But those are what changes the market on how they're trying to address the massive failure we had in February regarding us having the power needed for us to survive as individuals. Those two bills also provide the mechanism by which, I'm sure you've read, that over the next 30 years, you will probably be seeing a charge on your utility bill for paying back the billions of dollars that were incurred during that memorable one-week period in February of this year. Again, trying to cover these would take so much time, plus a little bit more of a securities and a finance degree than some of us may have. And so I wanted to, as a disclaimer, let you know I'm not going to covering those today. They just take too much time. They're too complicated, and we can't do it in as simple a fashion as we would like. So I'm focusing on three bills. Michael, can you go to the next slide, please? The first one I'm dealing with is Senate Bill 398. That amends the government code. And the reason I actually put the language from the SB 398 here is because I know we have some members that are members of cities, and I know that they've asked to see this particular language, but basically what Section 398 does is it prohibits a municipality, which is a city, from prohibiting or restricting the installation of solar energy devices by a solar energy system by a resident or a small commercial customer. And some of you, Larry Howe, I know, Michael Flatmark went to Tyler because I think Tyler had a law that prohibited rooftop solar. Well, that law has had to be changed since September 1. I know Michael and Larry and other people went to Tyler when that issue was going on during the summer to help try to educate the city of Tyler on what it really could not do. Michael and Larry, did I mischaracterize your participation in that in any way, shape, or form?
No, that sounds great. Thanks for bringing that up. And yeah, we had a good time in Tyler.
So there will be other municipalities that will have to amend their city ordinances to make sure that they don't prohibit or restrict. And prohibiting and restricting are two different standards, two different things that are not permitted. Now, what did Senate Bill 398 did not do? It did not change Property Code Section 202.010, which, as many of you know, is a homeowners association's ability to restrict or prohibit the installation of solar systems in their subdivisions. And I'll get to that in a minute, but I want to make sure that you knew that notwithstanding that the city may not be able to prohibit or restrict it, they might decide, for example, one of the ways sometimes parties react when something can't be done in a certain way, they find a different way to do it. Well, one of the ways they can do it is, since the law does not change the homeowners association's ability to prohibit or restrict the installation of solar systems, and there are limitations to that, but let me just say, a municipality could decide, well, the property owners association has this, so we might adopt a property homeowners association's rules and regulations on how they do that, and then we'll be in compliance with the local government code, but we're still going to have some restrictions in how solar systems are installed. So people in entities are no different. They find different ways of getting to the same point. Dharma, I see your hand is up. Yes, sir.
Yeah, Rosa, my question was that going back in time, when they, I think, Larry, correct me, it was four or 5 years back. I thought the law said that unless there was a compelling reason, the homeowners association could not turn down a request. Have they rewritten the rule to give the homeowners more power?
No, Dharma, if you will bear with me, I'm going to cover that as part of this presentation in a few minutes.
Thank you.
I hope it'll answer your question. The other thing that the Senate Bill 398 does not do in another method in which solar systems may still be restricted or prohibited is if the interconnection guidelines or the interconnection agreement of the city-owned utility or the rules of the Public Utility Commission. So there, again, there's another opportunity where you can have input on what the rules of the Public Utility Commission are with respect to solar energy systems, or the protocols of an independent organization certified under section 39.151 of the Utilities Code. That is one of the new entities that is created by one of the Senate bills that I indicated earlier I wasn't going to cover. That is one of those entities that is being created and certified so that they can make rules just like a utility can. So if either the city-owned utility, the PUC, or the certified organization limits the installation of solar systems because of their reliability or their power quality or the system of distribution or the safety of the distribution system is negatively affected, they can limit that. So as you can see, trying to unpack this specific provision, you have 3 different entities that can try to impose rules and regulations on 3 different bases. So you can see the matrix of 3 by 3 and however many different ways that comes up for the ability to limit the installation of solar systems. You would have to go through each of these entities with each of the 3: reliability, power quality, or safety of the distribution, and see what each one of those can do. So you're looking at at least 12 different ways that somebody can still get around Senate Bill 398 in the amendment to adding subchapter C to the local government code. That's how lawyers read these things, and that's why I'm trying to explain it to you in layman's language. Michael, can we have the next slide, please? So what did the authors have to say when they were stating their intent on why they were trying to change the law? And that is, they're saying that they're trying to change the law so that people can still exercise their personal property rights and the ability to generate your own electricity. And then again, if you have battery power, then you can help support yourself up to the level of your battery backup during an outage like we had in February. But again, as you see in their statement, it still allows the flexibility for homeowners associations and utilities to address customer protection issues, safety issues, but it does limit the scope of the city ordinances that regulate solar energy systems. So I thought in preparing this presentation, many times people will read the law as it was proposed, but they won't go to read what the author was trying to accomplish. And many times, especially when you get into court and you're arguing about what a specific provision means or doesn't mean, it is critically important to go into the author's statements and their statements of intent, because if something is ambiguous and you can't understand it without reference to other statements, this is a huge resource for being able to argue when you get into a court of law, whether something's prohibited or not. You will many times find great resources in the author's statements. So that's part of why I included them in the presentation today. Michael, can we have the next slide, please? So Dharma, you had raised the question of whether the homeowners association's ability to restrict or enforce provisions restricting or prohibiting solar systems had been changed. So I thought, one of the things I thought I would do would just to recap Property Code 202.010, which is covers what property homeowners associations can do with respect to solar systems. So again, here's the language. And again, a property owner association may not include or enforce a provision in a document that prohibits or restricts a property owner from installing a solar energy device. which is a solar system. Now, you have two different provisions there. One is they cannot include a provision or may not. And the second portion is if it isn't a provision already in the, as you all know, homeowners associations file their rules and regulations of the homeowners association and what's the limits of what you can and cannot do with your property if you purchase a home in that area that is covered by the homeowners association. And those are published. And when I say published, they're filed of record so that whenever anybody is looking to purchase a home, a residence in any area, you should make sure that your lawyer or your real estate agent pulls all the deed restrictions, pulls the property homeowners associations rules and regulations, because once you buy in, you are bound by the rules that are filed of record, and that's what they mean by a dedicatory instrument. That means literally the agreement that applies to the homeowners that live in that area that are covered by that homeowners association. And then 202.010C says that a provision that violates subsection B, which what we just read, is deemed to be void. It's void. It says it's of no effect. It doesn't count. And you would think that by reading just these portions of 202.010, that you're in the clear, that you're safe. Said, okay, they can't, even if I buy a home and it already includes provisions to restrict or enforce or prohibit solar systems, I'm in the clear, I'm fine, I don't have to follow that. Well, it's never that easy. So let's go on to the next slide. Subsection D of 202.010 says what they can do. And it says they may include and they may enforce a provision that restricts solar energy systems on each of, I think there's 7 different reasons. So if a court, if you have a solar system and you've been in a lawsuit and a court determines that your system threatens the public health or safety or violates a law, then the homeowners association declaratory document can prohibit you from having that solar system in place. If you're trying to install a solar system on property that's owned or maintained by the homeowners association, they can also prohibit you from installing a system on the property owned or maintained by the homeowners association. If you're trying to install a solar system on property that's owned in common, so there are certain areas of those subdivisions where the members of the homeowners association own property jointly with the residents, they can also prohibit you from placing a solar system on that property. Next slide, Michael. If you're trying to install a solar system on an area that is still on your property, but it's not on the roof, or another structure that they already allow under the homeowners rules, or if it's not in a fenced yard or a patio that you own and maintain, then they can also prohibit you from installing a solar system. So let's go on to the next slide. 5. Here's where a lot of us have seen where a lot of the disagreements come with the homeowners association. Dharma, you have your hand up? Yes, sir?
Yes, I do, Rosa. In line with that common property, if someone wants to engage in a community solar setup, is this rule prohibiting you from doing that?
That may very well apply. Yes, it can apply in community property situations. So if somebody wants to bring community solar to a particular area, they need to go check again, the deed restrictions. And if it's covered by a homeowners association, they need to go check the rules, because if it's property that the homeowners association owns, or property that is owned jointly with the residents, the homeowners association has a right to prohibit that community solar system from being placed on that property. Yes, it
Hey,
does.
Rosa, Michael here.
Yes, sir.
In regards to that, couldn't the owners hold a special meeting and vote to, if the majority votes in favor of doing a community solar development or something, they can overrule the homeowners association, or they can amend the rules?
Well, I was gonna say, I don't know that they could overrule them, because they are bound by that agreement when they bought into the residence. But what they can do is get together and either change the composition of the homeowners association, or follow the rules within the homeowners association document that says how you change the rules in the provisions of that agreement. So you have to go, it will depend on what the agreement says and how the homeowners in the area can change the rules so that you could have a community solar project in that area. But again, it's gonna take time and effort on the homeowners side. You don't just, it doesn't just happen because you want it, and that'll take time. And you have to, it all goes back to, what does that document say, and how does that document say you can change it?
Thank you.
Anybody else? I don't see everybody on my,
Well,
I just
Mullen
had
made
a-
a statement that he's in a homeowners Dallas Neighborhood Conservation District. And their ordinance there currently prohibits solar installations if they are visible from the street. Since the restriction is not in the city ordinance and not an HOA, does SB override the city ordinance restrictions? Does the state bill?
Yes, starting, and that's what I was talking about a few minutes ago. All these cities are gonna have to, either they're gonna have to look at it on their own, or else homeowners, citizens of that city are gonna have to bring it to their attention that they have a law on the books that is now prohibited by SB 398. And I'm sure that they are looking at it, because cities have representatives representing them in Austin every year. And I'm sure they are keenly aware of this provision. Those who are wanting to promote solar energy will probably be proactive and make the changes to their city codes on their own. Those who oppose solar systems for whatever reason will not be as active in moving forward with changes in the law. And then you're gonna have to, as James has just pointed out to me properly, you're going to have to go look at the historical designations and how those interplay with not only SB 398, but with the city codes themselves, because It may well be that under the historical or conservation district, different laws apply for those, and those laws may override or may conflict with SB 398, and so there has to be a reconciliation of those competing laws with each other.
Okay.
Okay. What,
Melon?
Melon?
The question, if I wanted to pursue it, I'd probably want to talk to my city councilman. And before you can do anything in our neighborhood, you have to get a certificate of appropriateness from the code people. Would that be a conversation you'd start with the code enforcement people for when you're applying?
My suggestion, Melon, is that you start that conversation with the conservation group that oversees your area. That's where I would start. But you're right, it's going to take a number of steps, but that's where I would start.
Okay. Thank you.
Sure. Anybody else before I move on to the most common areas that we see? Okay.
Rosa, Michael, I just
Yes,
wanted to
sir.
make a comment that Randy made a comment in the notes here that he's involved in an HOA where agreements do not allow change of the covenants or bylaws by simple majority. They require 80% for a change. So I bring that up because a number of us, I live out in the country, but I'm in a homeowners association and they do have limitations on solar, which is kind of crazy, but you need to know your homeowners association laws. So pull them out, take a look at them again.
Yep. Michael, I think you went one slide too far.
Okay, sorry.
Go back
Go
one,
back.
please. Go back. There we go. Okay. Let me turn to the area where we see most of these issues come up. And so the homeowners association can prohibit or restrict, and most of them are now just restricting rather than prohibiting your solar system on your roof. If your solar system is higher than or it goes beyond the roof line of your home. Or in many instruments now with homeowners association have areas where when you apply to have a solar system installed, they have a process in their instruments for the process you have to file, the application you have to file, the documentation you have to give them for them to approve your installation of your solar system on your roof. And in there, they have an area, for example, they might say that it would have to be installed in an area that does not face the street or the front of the house. It may be that the front of your house is southwest facing and is the best area where you can generate the most electricity, but the property homeowners association has an area designated that is not optimal. And so in that case, they can say, okay, you can install it, but it has to be in this particular area. The burden then shifts back to you to show that the area where you want to put your system in generates at least 10% more energy from your solar system than the area where the homeowners association says you have to put your system. And the way that is determined is you have to use a modeling program that is provided by the National Renewable Energy Laboratory to show that 10% higher generation for the area where you want to put your system in. And so sometimes you will have disputes where an individual comes in and says, look, it's more than 10% where I want to put it, versus where the homeowners association has said that you need to put your system in. And they may come back and say, well, that's fine and good, but you didn't use a modeling tool, a program, basically that is provided by the National Renewable Energy Laboratory. And I know that there are a number of those, but they're not all provided by the NREL. And so sometimes homeowners run into that issue. Dan, can you refresh my memory on which programs are out there by the National Renewable Energy Lab?
Yes, Rosa, there are two. By far the more common of the two is a program called PV Watts, and it can be run online. And from a simplistic perspective, almost anybody can use it, given just the basic information about the system. How big is it? What direction does it face? And so forth. PV Watts is probably, I'm going to say 80 to 90% of what's used in this instance. There's another program called Solar Advisor Model, or sometimes called Solar Advisory Model. A lot more complicated. You download what we call SAM, the Solar Advisor Model program, to your computer. You set it up and run it. PV Watts runs online. Those are the two.
There's a comment in the chat about what about restrictions on ground-based solar panels. In the previous slide, remember that there's the restriction that you can have it as long as it's on your property and it's fenced. Michael, if you can go back one slide, I think that's where it is, so we can answer that question. Okay. So you can have it, even though this is located on the property owner's property, other than, so they can prohibit if it's outside of this. So if it's in a fenced yard or patio that's owned and maintained by the property owner. So that covers the ground mount. You still have to have it in a fenced yard or patio. Okay, can we go forward again, Michael? Sorry. Okay, next slide. Again, they can prohibit or restrict the installation of your solar system on your roof if the installation does not conform with the slope of the roof and has a top edge that is not parallel to the roof line. Okay, so they have to have ways of installing them, and most installation companies don't have a problem with that. They know what they're doing there. Has a frame, a support bracket, or visible piping. So the frame of the solar panels themselves has to be silver, bronze, or black. You can't have a rainbow colored frame solar systems on your roof, so they can restrict or prohibit that. And then that's not a big issue usually either. Then E is that the Architectural Review Committee cannot withhold approval for your solar system if, next slide, please.
Yeah, I'm trying to get there. Is that it?
Yes. Oh, you went too far.
Oh, sorry.
If they can't deny your installation if you've met all the provisions of subsection D or you exceeded them, unless they determine that where you want to place your solar system is substantially interferes with another homeowner's use and enjoyment of their land, or causes them unreasonable discomfort or annoyance, people of ordinary sensibility. So the reasonable person standard out there, we normally see this as a nuisance. And what we have discovered over the last 3 to 4 years is that as we go through each of these provisions of 202.010 on roof mounted solar systems, as those of us who represent and encourage and want to encourage solar energy, as we knock down each of these subsection D provisions, invariably the homeowners association retreats to the nuisance type argument that the solar system is substantially interfering with the use and enjoyment of land by other homeowners. And I'll give you some examples of some of the things that sometimes homeowners associations claim. So for example, if you have a home in the back of your home, for example, or wherever you want to place your solar system, would be seen by a park next to the subdivision. And so they'll say, well, it's horrible and it'll be an eyesore for the people in the park. And the question is, well, do you own the park? No. So that knocks out part of that, that they don't own the area where they're complaining about would be affected. And there is one very quick way out of there, and that is that if where you want to place your solar system, if you're adjoining property owners, and there's a question of what adjoining means, it doesn't always mean just the people right next to you. If they all approve and consent in writing to where you want to put your solar system in, then it is not a nuisance, and the homeowners association would have to come in and prove, notwithstanding that all your neighbors say it's okay and they approve about your solar system and where you want to place it, then they can still come in and sue you to try to stop you from installing your system, or worse, once you've installed it, removing it, because that is possible, that happens too. Then they can still come in and prove that it is a nuisance. Now, what I'm going to get into next is why there is a lack of case law deciding this issue of nuisance in the context of installation of solar systems. And why is that? It's a very practical reason. Most solar systems that get installed or would be installed would cost less than $25,000. Most of them would. To decide this issue, because it will be a factual issue, a lawsuit has to be filed by one side or the other. And generally, the homeowners association will deny the application for the installation and retreats to this last nuisance position, and then dare the homeowner to sue the homeowners association. Well, therein lies the problem. Practically speaking, to have a lawsuit filed and tried to a jury in particular is phenomenally expensive. Lawyers are expensive, filing fees. There's a lot of expense in doing what lawyers call discovery, which is really getting all the information from the other side that they would rely on to challenge and say why your system's a nuisance, or why other reasons why they would deny your application to install your system. And it's literally a question of cost, and since the homeowners association has so to speak, the final say so in terms of saying, I will not approve this, then it really falls on the homeowner to file that lawsuit unless the homeowner is plowing ahead in violation of the terms of the lack of the approval, and then the homeowners association would file a lawsuit to stop that construction, and worse, if it had already been installed, to remove it. In one of the other concerns, while it is still cost, is that because these are basically agreements that people have made when they filed or when they bought the home in that area, is that if the homeowners association wins, not only do you have to pay your own attorney's fees, you would have to pay their attorney's fees as well. And you can imagine how expensive that would be. So on a very, very practical basis, as lawyers, we're not going to see a resolution of this issue in this specific context because of the cost involved, and especially not for just an individual homeowner. Dan, do you have anything to add on that? I know that you've had some experience with this as well.
About a year and a half ago, a number of homeowners associations tried to assert this nuisance clause, which are all fundamentally based on aesthetics. And it did become problematic for a while, but I believe we have at least a solution that you're going to be discussing. I'd like to revisit just a moment at the top of this present slide where it talks about subsection D, and there's 7 different points within that section of the law. They all either deal with electrical code as it's already existing or structural code. The simple fact is that you cannot safely extend solar panels beyond the edge of the roof, or they become a sail in a high wind and get ripped off from the roof, along with part of your roof typically. So those 7 items are already common sense. The rest of it is now moot thanks to this law. Other than that, no. Rosa,
Okay.
I don't have anything else other than just this nuisance issue has been a pain in the butt for a while, but I'm going to let you explain the rest of it.
Okay, let's go on to the next slide, Michael.
Okay.
Though it wasn't in 2021, in 2016, believe it or not, the Supreme Court of Texas finally had an opportunity to clarify what a private nuisance means, which is what the lawsuit would basically entail in a lawsuit over the installation of a solar system. And in 2016, you would have thought the issue of nuisance would have been decided many moons ago, but no. The Supreme Court of Texas decided that a private nuisance, which is what this would involve, must be based on conduct that constitutes an abnormally dangerous activity and not just an activity that is abnormal and out of place in its surroundings. So based on this ruling, nuisance, aesthetics, and annoyance cannot be asserted by HOA. I mean, they will, but it should not prevail. And you should be able to install your system. But again, you have to go back to cost, practicalities. There's a lot involved that even though you may be right, the cost of establishing that you are correct is lengthy and expensive. And it is highly unlikely that we will continue or that we will see a specific homeowner suing a homeowners association to overcome this. Now, in 90% of the cases, and I was I had taken a course in the continuing legal education classes that were required to have on this particular issue. And the three lawyers that were talking there was the lawyer for the homeowner, there was the homeowner for, the lawyer for the HOA, and then there was the lawyer for the installation company, who were all on a panel. And what they ended up doing, because they had already spent a bunch of money on fighting with each other, is they reached a settlement. And so that's what normally happens and you would be expected to happen in this kind of a situation. But again, even getting to that point will require a high expenditure of funds. And when you reach a settlement, 99.9% of the time, each party is going to pay for their own attorney's fees. Okay, so Dan, were you gonna chime in now on this issue?
Effectively, yes, what this is, you've very thoroughly explained it.
Okay.
There was a little
let's-
adjunct that I encountered.
Go
And for
ahead.
those that may be here for the first time, don't know me, I'm a licensed professional engineer here in Texas and in other states. I also sit on some national and state level code committees and boards. So I'm frequently called on to provide professional opinion. 2 years ago, I ran into an instance in an HOA where a neighbor to the east of a homeowner that wanted to install solar panels on two-story homes. The solar homeowner wanted to put them on the east side of their home, which is okay, generates some power during the day. But the homeowner to the next house east filed a complaint asserting we're worried about glare. They didn't want any sunlight reflecting into their home. And it took me 38 pages of complicated math to prove that it would not. Now, that was before some of this came to attention. I really think the true basis of that was they didn't want to sit there, as they indicated, in their upstairs library room and look at the neighbor's ugly solar panels, is what it really came down to. So aside from that, now with SB 398 and with this Supreme Court case that Rosa just explained to us, we've really got some substantial support that says, HOAs, you guys cannot assert nuisance, which you're looking at based on appearance. So hopefully this will alleviate some of the issues that people in HOAs have experienced until recently, especially now with the enactment of SB 398.
Dharma, you had a question? Your hands up?
Yeah, I do, Rosa. It's a two-part question. Based on the current slide that you have there, the last sentence which reads, based on this ruling, nuisance, aesthetics, and annoyance cannot be asserted by an HOA, POA, neighboring homeowner, members, etc. Is it safe to say that the onus is on all these folks to prove their costs instead of me having to spend buku bucks to justify it? Like what Dan just described, he said he prepared a 38-page. So
Unfortunately not, Dharma. I think that especially if the homeowners association still asserts that it's a nuisance, you can bring this up to them, and if there's no settlement, so to speak, or no resolution, then somebody has to file a lawsuit, either so that they can't stop you from installing the system, or for them stopping you from installing the system, and then that gets decided in the courtroom, and each party has to have their own burden of proof, but this would be extremely helpful for the homeowner who wants to install their solar system. Paul or Ann, you have your hand up? I'm sorry, before I go there, Paul and Dharma, you said you had a two-part question. What's the second part?
I think you might have answered the question, but still citing this language would not suffice, correct?
No, you still have to deal with it. Paul or Ann?
This is Ann, and
Hi, Ann.
hi. I actually had a friend in Deerfield, which is kind of a, it's large two-story homes in Plano. And she actually had solar panels installed, and then her neighbor filed a complaint, and I think they had a big lawsuit because of the glare. I'm just thinking, okay, get some blinds on that window if it's causing that much glare. And she had to take them off. So
yeah.
Anyway, this law would enable her possibly to put them back on. Is that what I'm understanding?
That is a possibility. Again, a lot of it will depend on what the homeowners association document has to say.
Okay. All right.
Rob, your hand was up next. I'm sorry, Ann, did I cut you off too early?
No, thank you.
Okay, thank you, ma'am. Rob?
Yes, it seems like what you were saying, that it would be risky but possible for the homeowner in that case to have a lawyer just write a letter and educate the HOA and then proceed to install it anyway. And that would force the HOA to have to sue the homeowner to stop it. And then if it goes to court, they most likely lose.
Well, the way these things go is a letter has not been sufficient up to this point. Now, this was before September 1. But then secondly, if the homeowners association has refused to allow the installation, even though they're claiming a nuisance, usually the document that's filed with the homeowners association and filed of record usually says that the homeowners association is entitled to an injunction to prohibit you from installing the system. If you install it and you don't have that permission, they can actually get an injunction to force you to take it down and then have the lawsuit proceed. And then once you prevail, then you can put it back up. You can imagine what that cost is going to be in the time. So no, it gets very difficult, and I would never recommend somebody to blatantly or to violate a provision of an agreement that's filed of record or not filed of record that they have already entered into. Melon, you were next. I'm sorry, Rob, you had a follow-up?
No, I was just going to say thank you. That's why I'm not a lawyer. You are.
Melon, your hand was up.
Hi there. It's sort of a follow-up to Rob's question, but I'll preface it by saying I'm of the opinion that it's better to apologize later and then ask for permission first. But is there some sort of preemptive measures you could take before I thought you pull your permit? that's the preemptive measure you need to take, and once the permit's granted.
Melon, I will give you the adage that, Michael, go back, we're not there yet.
Okay, sorry.
I'll give you the adage that we learned in law school. In law, unlike in love, it is better never to have litigated than to have litigated and lost. Okay, so no, asking for forgiveness doesn't really work in law. You would have double the cost, and you might even get punitive damages if you deliberately thwart an agreement that you've entered into. Dharma, last question, because I need to get to the rest of it.
Hang on, no, but if you pull permits, does that not then who can stop you thereafter?
Melon, pulling permits and getting governmental permits does not obviate the agreements and regulations that are filed of record that you are bound by when you bought your property where you are. Dharma, last question so I can continue with the presentation.
So, sorry, Rosa. In line with the permit issue, once a permit is issued, it's evergreen, right? The reason I ask you is if a new neighbor moves into my adjoining property, that can you go back and force me to pull down my installation, or am I preempted and protected under the previous?
Well, no, if your home already has a solar system on it that's been approved and what have you, when they move in, they would be bound by the same rules that you are under the homeowners association. And under those rules, your system was properly approved and installed, and they have no basis to come in and say, you know, I'm bothered by this now. Okay.
Okay. One other last question, I promise. I guess Anne had brought up this issue about the glare. What if me as an owner of a solar rooftop works out an agreement with my neighbor to put an anti-glare system? Is that a workable solution even before it goes to the attorney route?
I would suggest that anybody who wants to put in a solar system that's in a homeowners association that requires approval, follow the processes, including going to your adjoining neighbors, getting consents, getting approvals, getting resolutions. That works much, much better than having lawsuits. Much better. Okay, Michael, you need to go back one slide. Okay, let me move on. I know we're starting to get short on time here. SB 63 is another Senate bill that was approved this year. I put the $ in there because this saves you money. The tax code has been amended effective September 1 to provide for an exemption of the appraised value of a solar system that's owned by the person who's asking for the tax exemption, that's installed on real property and is primarily for the production of energy for on-site use. The difference from what was there before is that you don't have to own the real property on which the solar system is installed, which again may help with community solar. So for example, people can own the system that is on real property that is not owned by the system is not owned by the owner of the real property, but you, the owner of the solar system, can claim an exemption because there's personal property taxes and real property taxes that are imposed by counties. You can have, say that system now is worth, let's say that you put up a community solar system that is worth $100,000 or $200,000, and the county wants to tax that personal property on the tax rolls, on the ad valorem taxes. Well, you're entitled to request that the property or that value be exempted from taxation under the new section 1127 of the tax code that was amended. Now, the other provision that was changed in this in SB 63 was that people were asking, homeowners and businesses were asking for exemption from the appraisal district. And in some cases, it was taking a year or more for the appraisal district to make that determination. And so people were having to pay in taxes so that they wouldn't be defaulted and whatnot while that determination was being made. And sometimes, you know, the decisions would overlap even more than a year to a year or two. What this law does, it provides for a 90-day time period for the chief appraiser in the appraisal district to make the determination of whether you're entitled to that exemption or not. In the 90-day time period, you know, doesn't run from the minute that you ask for the exemption. it runs from the time that you'll file your exemption. They'll say, okay, we need X, Y, and Z. It runs from the time that you have provided all the information they have asked you to provide. So that's another provision that may save you money and may encourage and help with community solar, because now somebody other than the owner of the real property where the system is installed can apply for the exemption of the appraised value of that solar system from the appraisal district. Okay. Next slide, Michael.
Yep.
Again, the author statements on this one, to include it, it does say that you're entitled to the tax exemption based on the appraised value of the renewable energy system. And part of why they were doing this is because taxpayers would not receive timely notice of the chief appraiser's tax exemption determination. Okay, so again, this is something that's helpful, that should keep money in your pocket, and should also encourage, in particular, community solar or shared solar, because you don't have to own the real property where the system is located, is installed. Next slide. There's one, there are a number of laws that were changed, obviously, in the 2021 legislative session. But one that specifically pertains to business is, next slide, Michael, Senate Bill 760. And in this bill, amended the utility code to require solar farms, basically solar energy farms, facilities, to decommission the solar facilities when the useful life of the facility is done. So when you're ready to dismantle your solar power facility, your solar farm, there are now things that have to be done that were not required to be done prior to SB 760 and the utility code being amended as of September 1, 2021. So the things that the businesses have to do, stay where we were, is to remove your solar system, transformers or substations you may have installed on the landowner's property, because sometimes, many times, solar facilities lease the land on which they install the solar farm. They don't necessarily own the real property. They lease it. You have to remove any foundation, any underground cable. You have to go down at least 3 feet. And then you have to fill in the holes that are left in there with the same or similar soil type as predominated there before you installed your solar farm. You have to remove all rocks that are,
Sorry.
All rocks that are 12 inches or greater in diameter. You have to return the soil to what is called tillable state. And I'm sure there will be arguments about that. In addition, and this is very important for companies, you have to provide financial assurance that you will be able to comply with this law when you decommission your site. And what that usually translates into is, if you're not a large entity, you'll probably have to put up a bond or a letter of credit or some sort of financial security that will ensure for the homeowner that when this is done, that it can be complied with, and that the homeowner won't be stuck with a financial bill to restore the land to its previous site. And these requirements are not waivable by law. So when solar companies, solar installation companies, solar development companies are entering into agreements with landowners to lease the land. These provisions are going to have to be in those agreements. In there, if there's a waiver in there by the homeowner of any of these, those waivers will not be valid. Let me finish the 760 and then I'll get to questions because we are getting low on time. Michael, can you go to the next slide, please? Again, the statements from the authors were that oil and gas companies and wind energy companies are already required to pay to decommission their systems and their equipment and their projects when it's run the course of its useful life. And in the last legislative session in 2019, the same decommissioning requirements were applied to wind energy companies, but not solar companies. And so 760 is applying those same rules now to solar companies. Mark, yes, sir.
So the decommissioning of the solar installation seems to me to be kind of like what I consider the normal return to property to the condition it's in before you did your development type of provision. But I'm wondering because the gas companies have a similar provision and oil companies to properly close and abandon wells on sites that they've done wells on, but that is routinely ignored by those companies. And so I'm wondering, when it comes to the financial wherewithal to actually do it, you mentioned a bond. I think for a natural gas well, a bond is $10,000, which is nothing.
Right.
And so do you think the bond will be similar to that for clearing a solar installation from some property?
Mark, the reason the bond for oil and gas companies is $10,000 and it's not $10,000 per well, it's $10,000 period per operator, is because those are the rules that the Railroad Commission set up for them. What will be interesting, Mark, is to see if similar $10,000 type bonds can be put in place for solar energy companies and,
Right.
and other wind companies.
Right.
But otherwise, because every installation, every facility will be different, of different size. Again, I don't think normally you would not have the same level of bond or letter of credit or other financial assurance apply equally to each installation. And I think some of that is just things that will be worked out between businesses and homeowners and whatever the rules that get put in place by, I don't think the Railroad Commission of Texas has jurisdiction over solar companies. It may end up being the PUC. So that's another area where homeowners may, or businesses and individuals may participate and have their voices heard. Michael, can we go to the next section? Fini. Thank you all very much. I know that I went on too long, and I don't know if we caught all the comments or questions, but if there are any, I'll obviously stay and answer as many of those as we have.
Quick question.
Yes, sir.
You did mention earlier about the solar panel ground installations in backyards, and I didn't understand if you said that is still, they can overrule that, or whether you can do that.
You can have it in a ground mount in your own backyard. It will likely have to be fenced in, and you will have to maintain it.
Thank you.
Rosa, if I might add, there's one other
Yes, sir.
provision. And in many cases, a height restriction may apply Typically, fences are allowed either 6 feet or 8 feet tall, and in many instances, that aspect is allowed to stand. So the solar panels, if they're ground mounted, as long as they're on the homeowner's property, generally cannot exceed the height of the fence. This is going to
Yes,
have to be handled on a case-by-case basis.
Hey, Dan, Michael here. What in regards to, say, an 8 to 12 foot elevated pagoda that has solar panels on it? If that's allowed by a homeowners association?
I've had mixed results with those, Michael. What you're talking about, I often tend to call a pergola.
Yeah, pergola.
And in such instances, those so far have been allowed. But if it's a standalone racking mounted on the ground, those generally are restricted to the 6 foot or 8 foot fence limit.
Right.
Thank you all very much.
I know a lot of homeowners associations, they don't allow wood fencing. They only allow like wrought iron fencing or something so they can see through. So even if you have the ability to do a ground mount and if you can still see it, they may say it's a visual problem even though it's behind the fence. Have you come across anything like that, Dan?
I have. In fact, in the city of North Richland Hills, they had an ordinance 8 years ago that virtually prohibited all solar panels on a roof if they were visible, whether from the street or from the sidewalk approaching your home, which pretty well dealt with all of the surfaces of the roof. They then also included a provision in that same ordinance that said you can only have them in your backyard if they do not exceed the height of the fence, which was covered by an ordinance, and the solar panels had to be enclosed by what they called an opaque structure, which they were defining as like a block wall and so forth. If you had a solid fence, you could then mount them in your backyard. Well, with new SB 398, that has now overridden at least that city's ordinance. If you have a wrought iron fence, just because they're visible in your backyard is no longer grounds for the city to prohibit their installation.
But what about the
And-
homeowners association?
Same thing would apply to the HOA, just because they're visible. Doesn't matter. That's my professional opinion. I defer to lawyers for the final opinion on that, as well as the courts.
And
Skip
Michael,
Cave.
there's I'm sorry, Skip, go ahead.
Yeah, Skip Cave, I had a question about, I have a couple of acres that are, and one of them, and some of it is in the electrical easement, where the high voltage power lines go through. And I'm wondering, what's involved with putting ground mount solar underneath electrical easement?
Skip, that one's easy. You are not allowed to install solar, whether it's ground mount and the lines are above. You cannot install solar of any kind within an easement area.
Okay.
Which is unfortunate because all the high power line easements going through the state of Texas are prime real estate for solar.
That's exactly right. I'm about an acre and a half of my property is underneath the electrical easement. It's sad.
Yeah.
Yep.
Everything else is not under that easement is available for the development.
Yeah, I've got another acre on the other side off of the easement, so it's not a big deal, but it just happened that's a nice open space for the electrical for the ground mount.
Yeah.
No.
Rosa, is there
Yes.
someone else has something? Sorry.
Thanks a lot, Rosa. That was very informative.
Thank you.
Rosa, one of the laws that the provisions dealt with, the panels had to be framed, right? I think it's SB 760.
No. Michael,
No,
I
it's
can do that.
210.
Go ahead, Rosa.
Go ahead, Dan. Because he's
It
asking a
just
practical question.
It just referenced that the colors where present on the frames must be silver, bronze, or black. Those are the only colors available. It says nothing about frameless panels. In fact,
That was where I was going. Thank you, Dan.
Yeah,
no, frameless
Right.
panels are not a problem,
Okay,
and they're not required to be framed.
right.
correct. I mean, since it's not referenced, I mean, that, but I wanted a clarification on that. Thank you very much.
Now, years ago, we had panels that were purple, literally, and pink and other colors, trying to match the roof colors. Those didn't go over very well, and those are no longer. So we're back to the silver, which they reference as being a neutral aluminum color, bronze or black, which are anodized. And those are the three colors that are commonly available. I don't know, the overwhelming majority are either silver or black. I haven't seen bronze in a long time.
Yeah, I haven't either. Rosa, well, thank you so much. That was very enlightening. I think it is well worth this recorded meeting will be on our NTREG website later, and you know, it's well worth it. Any other questions you may have, you know, we can get them to Rosa, and hopefully we'll be able to get them posted on the website if required.
And thank you all very much for putting up with, I tried not to be too, use too much legalese so that we could convey this in as plain English as possible and have it be understood. Michael, if I might have one more announcement that I neglected earlier.
Okay.
We have elections coming up in January of this year. We have a number of positions. We would love for some of you to become more active in helping run this organization. We have undertaken additional projects like the internship program that we desperately need you to participate in. So please consider running for one of the board elections that is coming open, so that we can have the benefit of your skills and your input on a more direct basis than what we have at this point. We have the chair positions coming open. I am concluding my term. Treasurer is coming open, but we would love Michael to continue since we just started some pretty good streamlined procedures. We have a member at large position coming up, which helps as needed with different items. We have a membership coordinator and a program co-coordinator, which helps us put together the programs that get brought to you every month. So thank you so very much, and I appreciate your attention, and I hope I didn't bore you too much.
You're never boring, Rosa.
Not at all.
So I just want to bring everyone's attention to our next meeting, which is going to be October 9th. And remember, it's going to be Susan Alvarez doing a Dallas CECAP update, you know, what they accomplished last year and what's they're proposing to do next year. And we want to thank you all for attending. We want to thank our sponsors, being the Texas Solar Energy Society, the American Solar Energy Society, and our two primary sponsors for the DFW Solar Tour, being Dallas College and the City of Dallas. And thank you for attending. Stay safe, stay healthy, and please take some time out today again to remember 9/11.
Thank you all very much.
Cheers,
Enjoy
everyone.
the rest of your weekend.
Bye.
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 All right.
Thanks, Rosa. Thank you, Michael.
Sure, Eric, thank you.
Yeah, thank you, Eric.
Take care.
Good
Do we
job.
stop the recording?
We can stop the recording.